parking spaces, 4 tenants in place. Where's the numbers? We got rental. Yeah, it's 181. And then his net is coming out to property expenses monthly.
Recording in progress.
Hello.
Hello. How's everyone? Let's see. Can you guys see my screen?
It's loading.
Okay.
Good morning.
Good morning. Good morning. Can you guys see this contract? Okay. Let's see. Okay. Okay, we're gonna start in a few more minutes. I'm just waiting for more people to join us. 1 second. Everybody. Participants. Okay, so we're gonna start. Good morning, everybody. Okay. Okay, so here we're gonna do the training on the as-is contract. I'm stepping in for another agent that had to do this training. So here I'm gonna start you guys. Basically, we're on the first page of the as-is contract. This is the typical contract that's used for your purchaser or your buyer or your seller when preparing a sales contract. So on page 1, on line 1, basically most of the information that's gathered in this section of the contract, you can get it from the miami-dade.gov website or the property appraiser's website or IMAP. This here in the parties, you're always going to check the first and last name of the sellers, and you want to put both sellers' name. This form is really good. This is the one that we use here on the transaction desk. I've been using it for a very long time. I have all my files stored here. This is where most of my files are, and I already have templates for all these as-is contracts. So I just got to put in the address, and it basically plugs everything in. If you put your folio on transaction desk, your folio number to your property, it auto populates a lot of these questions regarding the legal description, location, and everything. You can put this stuff in from the beginning when you start the file. I could show you guys real quick. Hold on. Let's see. So here where you have the property and the information, you see how the property address is here. You can come here and you'll go to let's see. So we're gonna come here. This is the property. Hold on, I gotta move this real quick. And then here, you're gonna go to details. And in details, it's gonna give you everything on the property. You could put all this information in. If the property is listed on the MLS, you could put the MLS number, and it's gonna give you all the information. You put the folio. You can fill in most of this information here, and it's gonna be more details, and you're gonna scroll down. You could put the list date, contract date, everything. So a lot of this information is already gonna be there. Let me go back to the form. So here on the form, on page 1, you put the seller and the buyer's name. Basically, the seller agree that the seller shall sell and buyer shall buy the following described real estate property collectively pursuant to the terms, condition as is contract for sale and purchase, any riders and addendums. So this is a binding agreement between buyer and seller on this first line. Then it's the property description. It's going to describe the property address, city, and zip code. Okay, located in Miami-Dade County, tax ID, which is the folio number. The folio number is gathered from the MLS or from so on the MLS or IMAP. then you've got the legal description. The legal description can also be gathered from that, from the IMAP or the Miami-Dade Property Appraisers website for whatever county. So if you have Broward County, Monroe, Palm Beach, that information is going to be there as well. So it's going to, this information together with all existing improvements and fixtures, including building appliances, building furnishings, attached wall carpeting. This is all the property, the real property, and it's what it's attached. And then unless it's excluded on paragraph 1E. So these items are excluded if you put any items to be excluded. So if you have a chandelier, if you have something that the seller wants to keep, you need to make sure that information is provided in line 24, okay? In line 21, these are other personal properties that will be included. Let's say there's a water system, a water filtration system that the seller purchased additional, okay? That is going to be added in this line. So remember, if you do this, because a lot of sales have happened like this, you want to make sure that you include this information on the contract. So I just sold a property in Hialeah where there was a water system, and that water system's worth like $10,000. I put it on the personal, they put it on the personal property, but I had already stated on the MLS that that was not included. But the realtor came, offered, we came into negotiation. The realtor came up $5,000 on the price, and then they included that as well. So that's included on that contract. Make sure that is in this line, in line 21, what's included, and line 24, what's not included. Very important. Purchase price, line 27, section 2, page 1. It's for 1.7, the purchase price. This is another template for another offer property that we did a contract. Here would go your purchase price. This would be, if you have a purchase price of 300,000, you're gonna put 300,000, and then you put your deposit right under. Your initial deposit, your escrow, okay? This escrow amount is going to be held by a title company, okay? And this title company or escrow agent can either be an attorney, can be your preferred title company, whatever title company you work with, that's where you would fill this section in, okay? You would put the escrow agent's name, who is the escrow agent. You would put the address, you would put the phone number and email, okay? Typically on the deposits, when you get a contract executed, it's a 3-day due date for that deposit. So that is going to go on line 30. It's typically 3 days. So you see where they put, if left blank, you could either leave it blank. I always like to fill it in, and you'll go down this contract. This is just a template, but that I was working on. But you'll see that most items that are to be filled in, it's always good to fill them in, and you don't want to leave them blank. You don't want to leave them up for questioning later on down the road. So here, the 50K deposit, if you're using a finance transaction, this is any additional deposit to be delivered. So if there's an additional deposit, would go here. A lot of the times we're now getting contracts negotiated, and you want to come in stronger to get your offer accepted, you want to try to put in an additional deposit. And here you would put the effective date. Could be 10 days. That helps you with negotiations, especially in this market right now, how competitive it is. Okay. Hold on. Let me mute whoever's on. Hold on 1 second. 1 second. Mute.
Era de los ejercicios, tenía 159. Hay que ir a 50.
Hello, can you guys hear me? Hold on. Let me see. 1 second. Okay. Okay, so
Mami, no es la canción de las jodidas, es de la...
okay, so now you guys can unmute yourselves if you have any questions along the way, okay? I mute everybody, but if we have any questions, you guys can unmute yourselves, okay? So we're in line for the additional deposit. So on line 39, 36, here would be your additional deposit. If you have a finance transaction, right under that. So if you're doing 80% financing, okay, you're gonna put 80% financing, it's gonna automatically, okay, if the, let's see, 400,000. There you go. Okay. Okay, so it automatically calculates this for you. It tells you how much you would have to transfer to collect the funds, balance to close, financing expressing dollar amount. If you want to fill it in or you want to put the percentages, you can. Okay, this is automatically going to calculate it for you guys. Typically, you want to make a strong offer in today's market. So that's why I was telling you the thing about the additional deposit. So I'm going to give you guys an example where, okay, and then you could do 80% and it's going to automatically calculate it for you. Okay, that's the balance to close, not including buyer's closing costs, prepaids, and prorations by wire transfer to be collected. So you want to always let the client know, like, okay, this is not what you're going to bring to closing when you're doing a loan. There's lender costs, there's title company costs, there's different costs that are also incurred. This is your down payment. Okay, it's going to be part of your closing costs, but not including our closing costs. You want to be very, very transparent with the client and let them know this. Okay, here is your line 45, your time of acceptance. If not signed by the buyer and seller and executed copy delivered, a lot of the times you'll see this time of acceptance where it's changed and initialed. And this shall be deemed withdrawn and deposits, if any, shall be returned to buyer unless otherwise stated. Time for acceptance of any counteroffers should be within 2 days after the day the counteroffer is delivered. The effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer for final offer. So this final offer or your last negotiated price, once you execute that contract, that you have that last signature, that is when your contract is accepted. From that day moving forward is your inspections and start, your due diligence and start, your escrow days, the 3 days you got to deposit here starts. If you have an additional deposit, that's the day it's going to start as well. So the closing date, we go to the closing date. The closing date of this transaction shall occur when all funds required for closing are received by closing agent and collected pursuant to standard S for all closing documents required to be furnished. Each party pursuant to the contract are delivered unless modified by other provisions. This contract, the closing shall occur on such date. You can put on or before, or you can put a date. You can put a date. Typically, it's within 30 days, 45 days. If you're going FHA, you want to try to give at least 40 days, 35 days, depending on the lender you're working with. I've seen lenders close. I saw a lender just close a file for me on a sale. I think it was a $380,000 sale. They closed it in 25 days, the closing. So you want to speak to the lender and you want to make sure that when you're representing your buyer, that way you can have a aggressive offer to get accepted. You want to put that date here. If you have any extensions to the closing date, that would be your next section. In the event closing funds from buyer's lender are not available on closing date due to Consumer Financial Protection Bureau closing disclosure delivery requirements, if paragraph 8B is checked, loan approval has been obtained and lender's underwriting. This means that if you have a loan and your closing date is on this date, okay, on 6/30/2022, and you have any issues, if paragraph 8B is checked and loan approval has been obtained, lender's underwriting is complete, the closing shall be extended for a such period necessary to satisfy. So let's say the 3 days of trade wasn't given for some reason. You have, based on this contract, binding shall not exceed 7 days. So if you had a closing on June 30th and you weren't able to close because of the disclosure or anything in that sense, you have a 7 day, up to 7 days. Okay. Obviously, we like to always get extensions so we can protect our clients' escrow. As an agent, I pride myself in that. I don't like to leave what ifs up to lenders or title companies. You want to be assertive and you want to be on top of your contracts. Obviously, you have protections because that's why this contract is in black and white, but you want to be, you want to have the edge and you want to think ahead. So you want to talk and keep that constant communication with the lender. So you want to go ahead and tell them, hey, listen, are we going to need an extension? Yeah, look, we sent out the closing disclosures. We're going to need an extra 3 days, but don't worry about it. Based on the contract and based on stuff, we have that. Well, I personally don't do that. I go back to the listing agent if I'm representing a buyer and I talk to the listing agent, hey, listen, this is what's happening. Let's just get an extension for the next 3 days. We're closing on next Friday. The closing was supposed to be on Monday. Let's just say, in the event constituting, now here's section B, but this section here protects your client up to not to exceed 7 days, their escrow regarding underwriting and the closing date. In the event of constituting force majeure causes service. So this is basically like a hurricane. So if you have a hurricane, if you have a tornado, anything of that, let's say a pandemic was to happen, that would be a case of a force majeure. A lot of contracts go into properties go into contract and during hurricane season. So if you have a contract in hurricane season, all the due dates, all the deadlines, everything is extended because of this emergency. And that clearly says it here. Closing date shall be extended and provided in standard G. That's typical. And you would get an extension, or the client and seller could just wait till that event happens and decide if they want to continue selling or buying that property. The occupancy and possession, unless paragraph 6B is checked, seller shall at closing deliver occupancy and possession of the property to the buyer free of tenants, occupants, and future tenancies. So also at a closing, seller shall have removed all personal items, trash from the property, and shall deliver all keys, garage door openers, accesses, close applicable to the buyer. If occupancy is to be delivered before closing, buyer assume the all risks. So this section here is basically protecting the contract is protecting both parties, but if there's a post occupancy, if there's anything that's going to be left behind, if any of that stuff is there, it needs to be explained. It needs to be in writing. Okay. When this contract, they sign this contract, they have to understand that this is free of tenants, occupant, future tenancy, all personal items, trash, all that has to be removed prior to closing. That's why we do a walkthrough. So at the time of walkthrough, if you go, there's walkthrough forms, I believe, on the LR cloud. If you go through and use this walkthrough form, once you go to the walkthrough, if there's any items there, you can go back to the listing agent and explain to them, hey, listen, this stuff was left behind, needs to be picked up. That's part of the contract as well. If there's a post occupancy agreement or a lease after the fact, I've been seeing a lot of sellers, they want to sell their property, but they don't have, they need the funds to relocate. They want to relocate up north. They want to relocate to a family member's house, but it's not ready yet. They want to stay in the property for up to 30 days. You can do a post-occupancy agreement after closing. This is where you would check this box. So if the property is subject to a lease or any occupancy agreements after, that's what you would check. You would check this box. If the after closing or is intended to be rented or occupied by third parties beyond closing, the facts terms shall be disclosed in writing by seller and buyer. So you want a written agreement, something in writing between the seller and buyer. Anything to help protect your client is it's what our job is to do as agents. Okay. If there's a deposit or whatnot, any estoppel letters, if the property is leased. So if the property is currently leased and they're taking over a lease, they're going to provide estoppel letters. The title company, you can get a sample of an estoppel letter, but it's basically a document stating how much they pay, what's the amount, how long is their lease term for, their phone number, their contact information for that current tenant in place. Okay. You want all these writers and all this section, whatever is selected regarding post-occupancy extensions or whatnot, on page, on your last page, which is going to be your prior to last page, page 11, you're going to see here all these writers that are going to go along. So if you're going to do where we were at here on page, okay, extension of closing date, occupancy. So then we're going to assignability. So any section that you select these items, you want to also select it on page 11. Okay. Assignability. Buyer may assign and thereby be released from any further liability under this contract. May assign but not be released from liability under this contract. Buyer may not assign this contract if the box is not checked. The buyer may not assign this contract. Assignability is if you want to assign a contract. So if you are getting a property for your buyer and your buyer wants to assign it to an entity and they want to get, as long as they can still continuously get the loan, if they're buying with a loan, or if they're buying cash and they want to assign it to a family member, an LLC, here you would pick may assign and be released if they want to be released from the liability as that person, and they want to put the liability to the LLC. Let's say if a lot of wholesalers have this, they put may assign and released, or may assign but not released. If they want to continue assign the contract but not be released from it, then they can still do that, putting their name on the contract and assigning it to an LLC or assigning it to a corporation, and they're not going to be released. The typical norm when it's a finance transaction, it would be may not assign this contract. That is what typically is done here. Okay. So then here we go to financing. This is here on financing, you're going to have two. You're going to have a cash transaction with no financing contingency. So if you do cash transaction, you avoid the financing contingency. So that means if the property for some reason they do try to obtain a loan and the loan is not able to get approval or funding for any reason, this contract is going to be binding because it's going to be cash. So just always remember that, even if it's hard money. So if you're doing hard money, you want to go contingent upon financing, and you could specify here. So when I did this contract, it was owner financing. So here, if you want to select the contract is contingent upon within the left 30 days, you're going to put the 30 days here. Or if you leave it blank, you can leave it blank. A lot of lenders you speak to your lender, and to get a more aggressive offer accepted, you could put 20 days. If your lender has already underwritten this client and is firm that they can get this loan done in a shorter period of time and get you that approval sooner. Nowadays, lenders will tell you, I'll get you a loan approval in 5 days. So you could put 5 days to make your offer even more aggressive. Buyers obtaining approval of a conventional FHA, VA, or other. You could do other, could be seller financing, owner financing, hard money. You would put that here. The mortgage loan for the purchase of the property could be fixed, adjusted, or an adjustable rate in the loan amount at an interest rate not to exceed the percentage. So if left blank, it's the prevailing rate based upon buyer's credit worthiness. The 6.5 here is what my owner is financing this client when we made this offer. So they were looking for owner financing with 6.5%, and that was available in this transaction. If you're looking to do hard money, you would put hard money here, a fixed rate, and you could go to the terms that they're giving you. So the lender would give you the terms of your interest rate. If you leave it blank, it's going to give you the prevailing rate that's going on the buyer's credit worthiness. I leave this blank some of the times when I'm working with a client that we have not locked in their loan yet, and we're submitting offers. I would leave this blank, and typically that section regarding the interest rate, it's based on what their credit score is, their debt to income ratio. So for the term of 30 years, the financing, that's the typical, unless otherwise described from your lender. And buyer's mortgage broker or lender having received an appraisal or alternative valuation of the property satisfactory to the lender if they're required by a lender, which is sufficient to meet their terms and requirements for a lender to provide financing for buyer and proceed to closing appraisal. So this section also describes regarding if there's an appraisal. Buyer shall make an application for financing within the 5 days if left blank. So this means that within that time period, if you're going financing, your buyer has to make this application within 5 days, unless you put a different date here, and use good faith, diligent effort to obtain loan approval, meeting financing appraisal terms, and loan approval, which requires buyer to sell other real property, shall not be considered loan approval unless Rider V is attached. Okay. Buyer's failure to use a good faith and diligent effort loan approval period shall be considered default under the terms of this contract. So this basically, if the buyer's failure to use a good faith and diligent effort to obtain a loan approval within those 5 days, then they're in default under this contract. They can be in jeopardy of losing their escrow. Okay. So once you get this contract executed, you want to move quickly. You want to go ahead and submit this contract to your lender so they can start working on the loan approval right away. Buyers upon written request, keep seller and broker fully informed about the status of the buyer's mortgage loan application, loan processing, appraisal, loan approval, including properties related to condition and loan approval. Buyer authorizes buyer's mortgage lender and closing agent to disclose such status and progress, release preliminary and finally executed closing disclosures and settlement statements as appropriate and allowed to seller and broker. So by signing this, the buyer's authorizing for you to communicate with your lender as part of this contract, because obviously they're obtaining a loan and you want to have that open line of communication. This is in black and white, and it clearly describes. So if your seller, if your buyer says, no, I don't want you talking to the lender, they can't do that to you. You got to keep an open communication with the lender, because there's a lot of information regarding appraisal, loan approval, processing, all this information they need to communicate with you. And you have to have an open line of communication with the broker and the mortgage lender and the mortgage broker. If within the loan approval period, buyer obtains a loan approved, buyer shall notify seller of same in writing prior to expiration of loan approval. If the buyer is unable to obtain loan approval with a loan approval period, but buyer is satisfied with buyer's ability to obtain loan approval and proceed to closing, buyer shall deliver written notice to seller confirming same prior to the expiration of the loan approval period. If within the loan period, buyer obtains a loan, buyer shall notify. So within that loan period, buyer shall notify the seller. You always, once you get that loan approval, that's how a lot of realtors, they post, okay, approved. They'll post it, or they'll send a notification to the other realtor that the loan has been conditionally approved. that information, you can disclose it. If the buyer is unable to obtain a loan approval with the loan approval or cannot timely meet the terms of the loan, after the exercise of good faith and diligent, buyer may terminate this contract by delivering a notice of termination to the seller prior to expiration of loan approval. So before your loan approval period, which is, we put 20 days here, before that day, you find out that you're not going to get approved for some reason, appraisal didn't match, appraisal didn't reach the number, whatever the case may be, the person might have lost their job, anything in that time frame, you get a denial letter and you provide that denial letter, they will release your deposits. Buyers not in default under the terms of the contract, buyer shall be refunded the deposit, thereby releasing the buyer and seller from any further obligations to this contract. So as long as you provide a loan denial letter, you will get notification from your lender, provide that to the seller and the seller's agent, escrow will be released. You guys obviously have to sign a cancellation, but that will be released. If the buyer fails to timely deliver a written notice, so if he fails to deliver a written notice before the expiration of the approval period, he will be in default of losing that deposit. Okay. If the buyer has timely provided every either written notice provided to paragraph 8B above, the buyer thereafter fails to close this contract, the deposit shall be paid to the seller unless failure to close is due to seller's default of inability to satisfy other contingencies on the contract. Property related related conditions of the loan approval, specifically excluding the appraisal valuation, have not been met unless such conditions are waived by other provisions. So this contract is provided, is protected by the appraisal, okay, valuation, because it's part of the loan approval, unless you put on the additional terms that you guys are waiving the appraisal contingency. A lot of agents are waiving appraisal contingencies because the market is aggressive and they have to be aggressive as well. But if you're going to do that, you're going to put that information in either an addendum or in your additional terms on page 11. Closing costs, fees, and charges. Here's going to give you basically your breakdown of all your closing costs: title insurance, survey, home warranty, special assessments. This section here is going to tell you what's going to be paid by the seller and what's to be paid by the buyer. Seller will pay doc stamps and taxes and surtax on the deed. Owner's policy and surcharges if paragraph 9C is checked. So if we check 9C here and we put that the seller shall designate closing agent, buyer shall pay for the premium for the buyer's lender policy and charges for closing cost services related to the lender, endorsements on loan closing, which amounts shall be paid by buyers to closing agents such as provided as buyer may elect, or buyer shall designate closing agent and pay for owner's policy and charges. Typically, we go with Miami-Dade Provisional, which is buyer shall designate closing agent, seller shall furnish a copy of the prior owner's policy regarding the chain of title or evidence for the title and pay any fees for a continuation or update of such title evidence, which is acceptable to buyer's title insurance underwriter for the reissue of the coverage. Tax search, municipal lien search. So this section here basically is telling you that the lien search and the tax search is going to be paid if this section is selected, these fees are to seller shall furnish and pay for these fees unless the buyer is selected. So here you would go down through these fees and describe to your seller depending on what section you select here. The cost to be paid by buyer: taxes, recording fee, notes, mortgage, owner's policy and charges, survey, lender's title policy, endorsements, HOA association. All that information is described in this section here. The inspection, buyer attorney fee, appraisal fee, loan expenses. If you guys are representing a seller and you guys we have a transaction fee for lifestyle that you have to collect from your buyer or seller, you want to write that information here as well. You can. If you don't write it on the additional terms, you can put it here in other buyer or seller to pay processing transaction fee of the $4.95 to Lifestyle International Realty. Okay, here we go to the title evidence and insurance. At least if blank 15 days, 15, then 15 or paragraph 8 is checked, then 5 days prior to the closing date, title evidence deadline, a title insurance commitment issued by Florida licensed title insurer with legible copies of instruments listed as exceptions attached thereto, title commitment, and after closing, an owner's policy of title insurance shall be obtained and delivered to the buyer. So title evidence insurance, title insurance, this insurance and this information, if left blank prior 5 days prior to the closing date, you're gonna have to, the title company is to provide a title evidence and insurance on that property, on that before closing. Okay. So here we had the 3 boxes that we checked. So if check 1, seller shall designate closing agent and pay for owner's policy. We went over that because this information is what's going to lead you to this section here. Who pays what is based on what you select here on either line 168, line 172, or line 174. Okay. Regarding buyer shall obtain and pay for post-closing continuation and premium of the buyer's owner's policy, and if applicable, buyer's lender's policy. Seller shall not be obligated to pay more than $200 for abstract continuation of title search ordered or performed by the closing agent. So if there's anything additional that's left over for whatever the case may be after the fact, these $200 is the only thing that the seller shall be taken from the seller to cover for any abstract continuation or title search ordered or performed by the closing agent. Okay, so if there was an update on the lien search, an update on the title search after the fact, that $200 is what the most that they should be charged, unless you put otherwise here. Survey, at least 5 days prior to closing, buyer may at buyer's expense have the real property surveyed and certified by a registered Florida surveyor. If the seller has a survey covering the real property, a copy shall be furnished to the buyer and closing agent within 5 days after effective date. So within 5 days prior to closing, that's when they typically order the survey. The title company can order the survey throughout any time period during the transaction, but the norm is 5 days or a week before the closing date is when they order the survey. With the survey, you need it. So if you want to get permits, if you want to add an addition, if you want to do a fence, if you want to do a pool. So it's always highly recommended to get a survey. The home warranty. If there's any home warranty that the seller wants to pass on or the buyer wants to obtain, that home warranty is selected in line 184. If there's a special assessment, at the closing and the association has a special assessment regarding a full amount or liens imposed by a public body or regarding a condominium or homeowners association, this information, okay, it's a special assessment could be a roof that they're doing in the next 2 years. So they're going to put a special assessment in the condo community. Before closing, the amount of the public body's most recent estimate or assessment for improvement, which is substantially completed as the effective date, but that has now resulted in a lien being imposed on the property before closing. Buyer shall pay other assessments if special assessments be paid in installments. Check 1. So if there is a special assessment that has to be collected prior to closing, okay, if there's something after the fact, after closing, that the buyer is going to get, like a future special assessment, that's going to be after the fact. If it's before, seller shall pay installments due prior to closing and buyer shall pay installments due after closing. If the seller shall pay in full prior to the closing, or any assessment allowed by the public body to be prepaid for any assessment which the public body does not allow prepayment, option A shall be deemed selected for such assessment. If neither box is selected, then option A shall be deemed. I always go with option A. Seller shall pay assessments due prior to closing and buyer shall pay assessments after. Because if there's a future special assessment, that is going to be the buyer's responsibility, not the seller. Disclosure, if there's a rate on gas, if there's an area of chemical or high chemical area and you're selling this property, you want to add this addendum, and you have this rider that it's a rate on gas rider. You can go to section here on page 11, and here's all your additional riders. Okay, so here you could select your appraisal rider, if that for your appraisal contingency, seller financing, homeowners association, everything is here. All of your riders are here. Okay, now let's go back to the rate on, after the rate on gas. Okay, permits disclosure, except as many have been disclosed by seller and buyer in a written disclosure, seller does not know any improvements made to the property. So this section here, okay, it's very important that you guys pay attention. The permit disclosure, if there's open permits, if seller identifies permits which have not been closed or improvements which were not permitted, then seller shall promptly deliver the buyer all plans, written documentation. When you provide this on this contract, the seller has to close any open permits, liens, or violations. But I always write that on the additional terms. You want to put that here. Seller is to close all open permits, liens, or violations prior to closing. I always reiterate on that because I've seen so many sellers call me or buyers call me because they bought a property and there was open permits on the property and they didn't know. Okay. A lot of the times when they go under contract, they're not aware of what's open permit or what's closed until you pull a lien search. Okay, when you pull that lien search, the title company is going to inform you, okay, you have an open permit, you have this, you have that, you have to close this prior to closing. A lot of sellers will say, okay, I don't know what that is. I don't know, that happened 10 years ago. I don't know what, they don't know. Your job as a realtor is to find out and help resolve the matter. But in protection for your buyer, you want to always write that in there. I'll leave that once we get to page 11, I'll leave that there so you guys can write that down, but always include that in your contracts. Okay, except as may be disclosed by seller or buyer in written disclosure, seller does not know any improvements made to the property which were done without required permits. Basically, here is telling you that the seller is aware that anything that they did has done permits, and nothing that was done without permits they are unaware of. Okay, if seller identifies permits which have not been closed or improvements were not permitted, then the seller shall promptly deliver to buyer plans, written documentation, or other information in seller's possession, knowledge, or control relating to improvements. So I buy a lot. I just bought a lot for a client bought a lot with me that I found them, and there was permits already and there was plans. The seller passed those plans and those permits to us at the time of the contract was accepted and the time of closing. Everything was transferred over to the buyer. If there's mold, okay, mold is naturally occurring and may cause health risk. If the buyer is concerned or desired additional information regarding mold, buyer shall contact an appropriate professional. So that's part of your inspection period. Flood zone elevation certificate. Buyer, if the property is next to a body of water, it's probably in a special flood zone, unless when you go to Miami-Dade County or you go to IMAP, the flood zone, if it's X, then it's not located in a flood zone. Typically in Dade County, Broward County, you have a lot of flood zones. You're going to see that there is flood. Okay. And you're going to need flood insurance if you're getting a loan or your client wants to get a flood insurance. That's basically, you're going to have to provide that the property is located in a flood area. Your energy brochure. So there's an energy brochure that it's part of this contract that you can attach it. And it's in the additional, when you go to search on transaction desk, you go to brochure and it's going to pop it up there. Lead-based paint. If the property was built before 1978, you need to include the lead-based paint addendum. Always, a lot of agents will provide a lead-based paint prior to, you cannot provide the lead-based paint until the contract is executed, okay? You can attach it as part of the contract. The seller, the buyer to sign it first, and then seller to execute. So when you submit your offer, that you submit your as-is contract, and the house was built before 1978, always remember to submit your lead-based paint addendum, your disclosure. Homeowners association disclosure. If there's a homeowners association, if they have a maintenance fee, if it's located in a community where they pay a monthly fee, that information is also going to be, there is an addendum for that as well. And you're going to include that disclosure. You're going to find out what they pay monthly, the name of the association, and that information is written in that disclosure. Okay, foreign investment in a real property tax, FRIPTA. This is your FRIPTA law. If the seller shall inform buyer in writing, if the seller is a foreign person, a person from out of this country, has a visa, as identified by the Foreign Investment in Real Property Act, buyer and seller shall comply with FRIPTA law, which may require seller to provide additional cash at closing. If seller is not a foreign person, seller can provide buyer at or prior to closing a certification of non-foreign status. Basically, when you go to sign and you go to closing, they're going to ask you, are you a U.S. citizen? And that's when that information is disclosed. If you were a foreign person, the title company is going to require you to provide, and your FRIPTA law is going to come into place. Seller's disclosures. Seller's disclosures, when you go to submit an offer and you get your offer with your lead-based paint and submitted, you want to get that seller's disclosure. You want to ask that agent for the seller's disclosures. This is going to tell you any known facts regarding this property, okay? You want to understand what is going on with the property, and the seller knows or of any no facts, materials affecting the value of the real property which are not readily observable and which have not been disclosed to the buyer, except as provided for in the preceding sentence. Seller extends and intends no warranty and makes no representation of any type, either express or implied, as the physical condition of the property, of the history of the property, except as otherwise disclosed in writing. Seller has received no written or verbal notice from any governmental entity or agency as to currently uncorrected building environment and safe code violation. Okay, anything on the seller's disclosure is going to be provided in there. Property maintenance, except for ordinary wear and tear, casualty loss, seller shall maintain the property, including but not limited to lawn, shrubbery, and pool in the condition existing as the effective date of the contract. So if the contract was executed, you have the property has to be kept in well maintained, should be kept to where the owner, the buyer, went to see the property. So if the buyer went to see the property and the grass was cut and everything was clean and no windows were cracked, when they went into the kitchen was super nice, but now they go to the property and they have a bunch of paint on the house, that the seller is responsible to correct these issues. Broken window, if it wasn't there at the time of the inspection or at the time this contract was accepted. Okay, right to cancel your property inspection. So this is very important to provide your seller, your buyer, with ease of mind regarding inspections. So your inspection period protects your buyer if they want to cancel regarding inspections. So if there's something that comes back on the property, that is maybe a double tap on the electric panel, broken tile that they couldn't see, maybe in the roof was old and you guys weren't aware of the age of the roof, anything damage to the property, any damages that were not visible, okay, termites, anything of that nature, when you do the inspection, okay, you do your inspection and your response from your inspector has to be within 10 days of the effective date, or 15 days if left blank, whatever number you put here. If you want to put 5 days because you want to have an aggressive offer, you want to put 5 days, you're going to put these 5 days are going to be part of the effective date after. So you have to get, and once you get your inspection report, you're going to provide a written notice. If there's any cancellation, you have 5 days to do that. And that's when you could get, if it passes these 5 days, your buyers could be in jeopardy to losing their deposit. And typically sellers go after the deposit because this timeline was not, was passed. Okay, walkthrough. This is what I explained to you guys on the day prior to closing or closing date prior to, as specified by the buyer or buyer's representative may perform a walkthrough. Always go do a walkthrough with your client prior to the day prior to closing, so that you could check everything and make sure everything was in the shape that you guys saw the property when you went under contract. Seller's assistance and cooperation and close out of building permits. So if there's a building permit, anything open regarding a illegal addition or any of that, if buyer's inspection of the property identifies open or needed building permits, the seller shall promptly deliver to buyer all plans, written documentation, or other information in seller's possession, knowledge, or control relating to the improvements to the property, which are the subject of such open or needed permits. So if there's an open permit or any of that nature, that this is protects and is part where the seller is going to assist and cooperate and close out of building permits. Assignment of repair and treatment of contracts and warranty. At buyer's option and cost, seller will at closing assign all assignable repair, treatment, and maintenance contracts and warranties to the buyer. Escrow agent. Here it's going to tell you who the escrow agent is, who's going to be holding escrow on the wins is part of the page 1 of your contract. So that goes back to page 1 of your contract. You got the broker's liability. You guys want to read this thoroughly. You got your broker liability. Broker advises what your responsibilities are as a broker. Buyer agrees to rely solely on seller's professional inspectors and governmental agencies and verification of property conditions, square footage, and facts that materially affect property value, and not on the representation or order written otherwise of broker. Okay, this information protects the parties and it describes what the broker's performance and representation is, okay, and our liability. So you want to always read this section thoroughly. Broker advises buyer and seller to verify property conditions, square footage, other facts. So these are all information. So this information that you give to them, they have to verify, okay? They cannot just go based on what you're telling them. Broker represents the buyer and the broker does not reside on the property, and that all representations or written by the broker are based on seller's representation or public records. Okay. Default and dispute resolution. So this is page 7 of the contract. Default, buyer default. If buyer fails or neglects, refuses to perform buyer's obligations under the contract, including payment or deposit within the times specified, seller may elect to recover retained deposits for the account of the seller as agreed upon, liquidated damages, consideration for execution of contract, in full settlement of any claims, whereupon buyer and seller shall be relieved from any further obligation to this contract, or seller at seller's option pursuant proceed in equity to enforce seller's right under this contract. The portion of the deposit, if any, paid to the listing broker upon default by the buyer shall be split equally between listing broker and cooperating broker, provided, however, cooperating broker's share shall not be greater than the commission amount listing broker had agreed. So this goes back to your listing agreement. So if there is a default on the contract and you put a cancellation, a 50% retention of deposit, out of the 50% retention of that deposit for the default of the buyer, that deposit is split equally between the brokers. Okay, if there's a buyer's default, that escrow is due to the seller. Okay, and the seller still has an obligation with the agent that listed the property and the buyer's agent Okay, and that commission could either be 50-50, 25-75, whatever is stated on the listing agreement. Seller's default, if for any reason other than failure for the seller to make seller's title marketable after reasonable diligent effort, seller fails, neglects, or refuses to perform seller's obligation under this contract, buyer may elect to receive return buyer's deposits without thereby waiving any action for damages resulting for seller's breach, and pursuant to paragraph 16 may seek to recover such damages or seek specific performance. So the buyer, if the seller defaults and doesn't close for whatever reason, based on what this contract agreed to and the terms of this contract, the buyer can sue for specific performance. They could hire an attorney, you would provide the copy of the contract, and they can go after the seller for, the buyer can go after the seller. Dispute resolution, it's going to give you the resolution to dispute regarding the matters arising out or relating to the contract or in breach, enforcement, or interpretation will be settled as follows. Buyer and seller will have 10 days after the date conflicting demands of the deposit are made to attempt to. So once the seller or the buyer demands are written, okay, they have 10 days after. Buyer and seller shall submit such dispute to mediation under paragraph 16B. Buyer and seller shall attempt to settle disputes in an amicable manner through mediation pursuant to Florida rules for certified and court-appointed mediators as amended. This is something that would go into a civil, okay, matter. To the mediator must be certified or have experience in the real estate industry. Injunctive relief be sought without first complying with this paragraph 16B. Okay. According attorney fees cost, the parties will split equally any mediation fees incurred regarding mediation by this contract. Each party will pay their own costs, expenses. Basically, you hire your attorney, I hire my attorney. Okay, that's section number 17. Number 18, title evidence restriction, easement limitation. Here is going to stipulate anything regarding easements. If there's a public utility, if there's any zoning ordinances, all of this is going to be part of title, and it's going to be part of the title commitment. They're going to describe on your title commitment and your title policy whatever easements, whatever is not part of the property that the seller or the buyer may think it is, but that area belongs to the city. Let's say if there's a power line running behind the property, that is part of this section here, where that easement is going to be written on that title commitment. Okay. Standards for real estate transactions continue. Title examination. Buyer shall have 5 days after receipt of title commitment to examine it and notify seller in writing specifying defects. So if there's any title defects, if there's anything regarding easements, encroachments, if there's anything regarding a chain of title, any of that information, they have 5 days after receipt of the title commitment to examine it and notify the seller in writing. Okay, if seller provides title commitment and is delivered to buyer less than 5 days prior to closing, buyer may extend closing date for up to 5 days after the date received to examine same in accordance with this standard 8. Give me 1 second, guys. Hold on. Okay, survey. If a survey disclosure encroachments on the real property or improvements located thereon encroach on setback lines, easements, or lands, otherwise violated the restriction covenants of applicable such matters, together with a copy of the survey to the seller within 5 days after receipt of survey, but no later than closing. If the buyer timely delivers such notice and survey to the seller, such matter identified in the notice of survey constitute title defect. So if there's when they do the survey prior to 5 days of the closing, if something comes out, the buyer can notify the seller and the seller has to correct that issue. Okay, if there's something where the fence is on the property line that the neighbor's fence is on the property line that you're purchasing the property, that has to be corrected by the seller, and that's why we get a survey. Ingress and egress. Seller represents that there is an ingress and egress to real property, entitled to the real property is insurable and according without exception for lack of legal right of access. So you need to be able to enter and exit the property. Okay, that's your ingress and egress. Seller lease information. Seller shall at least 10 days prior to furnish buyers estoppels. This goes back to the estoppels, the leases, and any estoppel letters. Okay, it's going to tell you 10 days prior to closing that estoppel letter needs to be provided to the buyer. Okay, you always want to sign something like an affidavit, and this here says if estoppel letters or seller's affidavit, if any, differ materially from the seller's representation and lease provided pursuant to paragraph 6, or the tenant's occupant fail or refuse to confirm seller's buyer may deliver written notice to seller within 5 days after receipt of such information, but no later than 5 days prior to closing date, terminating this contract and receive a full refund of deposit, thereby releasing buyer and seller from all further obligations under the contract. Seller shall at closing deliver and assign all leases to buyer, who shall assume seller's obligations thereunder. So if you have estoppel letters and you're buying a property and you're assuming the tenants, you have the seller has to provide this estoppel or affidavits to the buyer. And you want to obtain that, and you want to ask those questions to the listing agent or your cooperating agent. Liens. Seller shall furnish to buyer at closing any affidavit attesting to the absence of any financing statement, claim, or lien. So if there's any liens on the property, okay, regarding a violation that turned over into a lien that's been accumulating, okay, you want to the real property for 90 days immediately preceding the closing date. If the property has been improved or repaired within that time, seller shall deliver releases or waivers of construction liens executed by all general contractors, subcontractors, suppliers, material men. A lot of times when they're doing work on properties, okay, a GC, a person doing work will put a notice of commencement on the property. You want to make sure that any liens, any notice of commencement, any of that stuff is removed. When they pull title, that is going to come out. The seller is responsible for that to clear that issue. Time is of the essence of this contract. This is going to tell you basically on the timelines again. You're going to have the force majeure, which we spoke about. Force majeure is hurricanes, floods, extreme weather, earthquake, fire. I saw a lot of people regarding the pandemic. You see where it says here, pandemic, it was a part of the force majeure. So anytime we had contracts extended, deadlines extended, contracts with the time of acceptance and due diligence period, your escrow deposit will be extended. And then the contract for more than 30 days beyond the closing date, okay? So here, basically, the force majeure in the event including closing date will be extended a reasonable time of up to 7 days after the force majeure event is no longer prevents performance under this contract. So once the hurricane is up, once the pandemic was up at the time, you have 7 days for this contract to start moving forward again, okay? 7 days after. Conveyance of the conveyance of the title. Sellers shall convey marketable title to real property. You want clear and marketable title. This is what basically this section is describing to you. Convey marketable title to the real property by statute to warranty, trustees, personal representative. So they're giving you conveyance of title, and they're providing that here in this section. Closing location, documents, and procedure. Locations for the closing. This is going to describe what's going to be part of the closing, the day of closing. Closing will be conducted by the attorney, and they will notify the parties. The closing documents are going to be your closing package, your loan package for sellers, the seller docs, the FinCEN GTO reporting obligation. If closing agent is required to comply with the U.S. Treasury Department's Financial Crimes Enforcement Geographically, the buyer shall provide closing agent with essential information and documentation related to the buyer and its beneficial owners, including photo identification. Any information here, this is it has to be provided at the closing. Procedure: the deed shall be recorded upon collection of closing off funds if the title commitment provides insurance against adverse matters. So if the title commitment is provided with insurance, the deed shall be recorded. As amended, the escrow closing procedure required by standard shall be waived, and closing agents subject to collection of all closing funds. This collecting of all closing, dispersing closing, broker fees, that's when we get paid. That describes that in the procedure. Escrow closing procedure. This is your escrow closing procedure. If title commitment issue does not provide for insurance against adverse matters as permitted under section 627.7841 as amended, the following escrow and closing procedures shall apply. Here's going to tell you the closing procedures. There's several different ones. Our closing procedures shall be held in escrow by closing agent for a period of no more than 10 days. 2, if seller's title is renderable unmarketable, though no fault the buyer shall within 10-day period notify the seller in writing of defects, and seller shall have 30 days to cure, to basically, if there's something that comes back on title and it's unmarketable, the seller has 30 days to clear this issue. If seller fails to comply and cure defects, okay, the deposit and all closing funds paid by the buyer shall be within 5 days after written demand by buyer will be refunded to the buyer, okay? Buyer shall take title, here we go, shall be refunded to the buyer, and simultaneously with such repayment, buyer shall return the personal property, vacate the real property, and reconvey the property to the seller by special warranty deed and bill of sale. If buyer fails to make timely demand for a refund of deposit, buyer shall take the title as is, waiving all rights against seller as to any intervening defect except as may be available to buyer by virtue of warranties contained in the deed or the bill of sale. Okay, prorations credits. If there's any prorations credits given to the seller or to the buyer on this contract, here's your section. You're going to always do an addendum to get any credits that you want to get based on inspection. Any of that information, you want to try to always have it within your inspection period, okay? Any prorations is going to be taxes prorated. Anything is going to be also as well on the HUD. It's going to show access to the property to conduct an appraisal, walkthrough. Seller shall, upon reasonable notice, you always want to give a 24-hour notice to do appraisal, to do a walkthrough if your client wants to see it. The buyer wants to re-see the property, they want to redesign the house, you have to notify them in writing, and always let them know at least 24 hours in advance. Risk of loss: if any after effective date before funding, property is damaged by fire, basically at that point in time, if everything is not to the buyer can back out, get his escrow back. 1031 exchange: if there's a 1031 exchange, all these riders are going to be selected, so you want to select them here. Basically, risk of loss, 1031 exchange. A contract not recordable, persons bound, delivered copies, contract execution, integration, modification, waivers, riders, collected or collection or collected, applicable law, venue, FRIPTA. Okay, these stuff, this is your important page 11 and page 12. All these pages are important, but these are the ones that are the writers for the sections above prior to. So here's regarding the IRS withholding certificates, not withholding any. This is for foreign persons. This is going to describe the FRIPTA law. Here in your addendums, you're going to select your addendums. You're going to have your condominium rider, homeowners association rider, seller financing rider, mortgage assumption, FHA, appraisal contingency, short sale rider, homeowners flood insurance rider, interest bearing, okay, defective Chinese drywall, coastal construction, insulation disclosure, lead-based paint, anything before 1978, you select. FHA, you select. Anything that you're doing, you want to select these items. Okay, it's seller's attorney's approval, buyer's attorney's approval. Okay, if you want to do post occupancy, pre-occupancy, if they want to move in before, if they want to keep tenants prior to. Okay, sale of the buyer's property, if the buyer has to sell their property. Okay, if this is a backup contract. Here, I basically gave you the additional terms. These additional terms, sellers to close any all permits, liens, or violations. These are some terms that I put in for the seller financing. Here's my commission. If I'm not collecting commission on regarding representation. And this was a template that I used for a family member. So I wasn't collecting commission, but I had provided them with a template, with a contract, with an as-is contract, but they wanted me to prepare it and provide it to them. So I prepared the contract for them, and I did all the necessary changes, but I'm not collecting commission on it because it was a family member and they needed help. So I provided this for them, and I have to write that as well. So I put that in there. Here's the intended to be legally binding if not fully understood. So here, if there's a counter offer, the seller's counter to the buyer's offer. Okay. Your signatures, very important. Your broker, if you're a broker, your realtor information, you always want to put this here. Your information of your real estate, and you always want to put 3% or 2%, whatever your percentages are. Okay. You always want to write that in there. This protects your commission. So very important. This section is very important for commission. I've seen a lot of agents where they've put on the MLS, they put 3%, but the time they do the contract, okay, they change the MLS. Even though they put in whatever's on the MLS and you showed on that day, that commission is due to you, I always write my commission here to protect me. Okay, so here's your additional terms. I hope you guys got as much as information regarding the as-is contract. Always very important to stick to your due dates and your deadlines. Get a very familiar with this contract because it's very important to know how to protect your buyer. Okay, this contract protects a lot of the seller, but you want to get this contract to protect your buyer as well. You want your inspection days, inspection period, your counter offer period, because right now you have it's an aggressive market. So when you make an offer and they're going to make a counter offer, you want to make sure all signatures are signed, all initials are put in place. I hope this as-is contract training helped you guys out. Any questions or anything like that, you can email me. I'll put my email. Let me put my email here. 1 second. Hold on. Chat. I'm going to put it on the chat. 1 second. If I got a question from Roxette. If a seller wants to sell their home but still owes mortgage on it, how can this be resolved? The seller, if they have a mortgage on it, part of title, they're going to ask for the loan number. They're going to pull the type on, they're going to pull the information. They're going to get a payoff. The title company is going to get a payoff. And whatever balance is resolved from the time that they sell the property. Okay. Let's see if Roxette is still on here. Hold on. I believe she still is. Hold on. 1 second. Okay. Yes. So Roxette, if the property has a mortgage, the title company is going to ask for a loan number, and they're going to get a payoff. Once they get that payoff, you're going to basically give your seller a seller's net sheet. On that seller's net sheet, they have it on the MLS. On the MLS, you go to MLS. It's going to tell you. Let me show it to you guys. Hold on 1 second. I'm going to show you here. Hold on. Second. Okay. So can you see my screen? You could still see, you see the matrix? Okay, so here where it says finance, okay, where it says finance, you're gonna go to seller's estimated net proceeds, okay? And here in net proceeds, you're gonna go down and it's gonna let you put the name, the address, everything. And here in the section regarding what they owe, your present mortgage payoff, okay? You're gonna put your present mortgage payoff. You're gonna get that mortgage payoff. You're gonna put all the information, put your brokerage fee, and you're gonna describe that. And here's gonna give them, you could save this net sheet, you can email it to them, you can provide that to them right there. So that's gonna basically describe everything to them. So yes, the mortgage, to answer your question, still owes a mortgage on it. How can this be resolved? By getting a payoff, and finding out the title company will send an email or a fax to the lender to get a payoff for that loan. Okay, guys, have a great afternoon, and thank you all for having me. Best of luck to all. Have a good one.